Okay, we are live. How you doing, Zach?
I'm good. I'll apologize to the viewers that we were having a little bit of an audio issue on my end, so I've gone back to the prior version of audio, so it may not be quite as clear, but we're going to try and get that solved for you before we go live next.
It's still pretty darn good, I gotta say.
Good.
Yeah, the audio sounds good. So, guys, updates in the Danny Masterson trial with respect to Lisa Marie Presley. I'm also going to surprise Zach with some questions relating to the Paul Haggis trial, just for fun. But so Zach, tell me what we should think about Lisa Marie Presley not testifying after she was granted immunity and after the judge narrowed the scope of what kind of testimony she was going to allow from Lisa Marie.
Sure. So I think what it comes down to is the scope of the examination that she was going to be subject to was no longer helpful. It goes back to, I think the first time we spoke, we talked about duplicative and repetitive testimony and how you can't just bring 50 witnesses say the same thing 50 times.
Mm-hmm.
And so I think we were approaching the duplicative point of the testimony. Additionally, there were going to be some hearsay issues because of the basis under which the testimony would be possibly admissible, the argument to get in. Like, we've talked about, and it's a little bit nuanced, it's hard to explain, but if I try to get something in for the truth of the matter, it's hearsay, but if it's not the truth of the matter, or not for the truth of the matter, it's not hearsay. And so if she is testifying that Jane Doe told me that Danny did these things, well, yeah, if the testimony is trying to come in to support the fact that Danny did those things, that the statement was true, it's hearsay. But if it's coming in for the prior consistent statement, which is she's told everybody all along this happened, not that the statement is true, but that the statement was made. And there's already been several corroborating witnesses that have all said Jane Doe 1, 2, 3, whoever made this statement to me that this bad thing had happened. So I think the prosecution was looking at it from, do we really need this? And also the judges essentially told the prosecution, I need you done this week. And I think there's only going to be a half a day of testimony tomorrow. I think it was either today or tomorrow. There's only going to be a half a day of testimony because one of the jurors has some sort of conflict that the judge has agreed to dismiss court early and adjourn at noon instead of at the end of the workday. And it essentially the prosecution was forced to make a decision. I don't know that it's a bad decision if they have other testimony to support that, and the judge was going to limit Lisa Marie's testimony anyway. I don't know that that's damaging to the prosecution in any way. If they're looking at, if you think of it in terms of ammunition, what do we have left to pick from? If we only get the choice of 2 of the 3 weapons left, let's pick the 2 that are going to be most beneficial to us, and it may not be Lisa Marie.
Right. So there's a difference between testimony for the sake of showing that someone has been consistent as opposed to showing whether someone is telling the truth or lying.
Exactly. I can admit really about any type of testimony that a conversation occurred to prove that the conversation occurred, not to prove that what was stated in the conversation is a true statement. Okay.
So here's what has me stumped here, right? Because if we go, all right, after the judge said, Lisa Marie is not going to be able to say who asked her to help obstruct justice, and she's not going to be able to testify about reporting back to Scientology, reporting the results of her conversation with Jane Doe 1. If that ruling from the judge is what made the prosecution go, oh, well, then her testimony doesn't matter, it makes it seem to me that they only wanted her to testify to talk about the Scientology connection, which confuses me because that doesn't speak to Danny's guilt or innocence. Why would the prosecution waste time with testimony about Scientology's involvement in something at this late stage in the trial? I don't totally get it.
I think that's exactly it. I think when the immunity was negotiated and then they decided they of course have to tell the other side that they're going to call her. This was of course before the restriction on the testimony. So they had all this testimony lined up. The judge issues a limiting instruction on the type and nature of the testimony. And the prosecution looks at it and says, I don't think, a couple of things. We may not get where we need to get in time. We may not be able to get there at all. Or the inconvenience, the threading of the needle that I'm going to have to do this is simply not worth the value of the testimony that I'm going to extract.
That makes sense. That makes sense. So you mentioned something to me earlier about the important difference between use immunity and general immunity. Do I have that right?
Exactly. Yeah. So I sent you and I said, hey, remind me to mention this when we talk to the viewers, because I'd seen some comments along this talking about immunity, and I actually used the wrong word. I called it general immunity, but it's actually called transactional immunity. And it's just a concept I wanted to explain to the viewers, because I don't know exactly what type of immunity Lisa Marie Presley has been granted in this case. But immunity comes in two types. There's something called transactional immunity, which says we, the prosecution, agree that we can never use what you say ever against you within the limits of, in this case, the obstruction of justice. If Lisa Marie Presley makes a statement that she violated some other law or otherwise acted in an unlawful manner other than the obstruction, that's not, she's not protected from that. But transactional immunity says if they grant a transactional immunity, any statement that she makes ever about obstruction of justice, Danny Masterson, Scientology, all this stuff together, they can't prosecute her for it. Then there is a narrower type of immunity called use immunity. And that says we are immunizing you against prosecution for statements you make that admit to obstruction for this case. And that doesn't mean we can't prosecute you for this same obstruction later, but it means that we have to go and gather independent evidence that you obstructed, because if I try to use your testimony that you made here to convict you later, that's not admissible evidence because it's immunized. But if I can call 10 other witnesses that say I conspired with this person to obstruct, that comes in. So transactional immunity says it can never be used against her to convict her ever for any reason. Use immunity says they cannot use what she says in this trial to try and convict her in the future. But if they can find independent evidence, because the prosecutor may very well know, obviously they know this happened. And if they say, we think we can get other evidence, so we'll immunize your testimony, but I got 10 witnesses back behind this door that are going to testify, I can give you use immunity and still prosecute you. If I give you transactional immunity, which is what they gave Bill Cosby, if I give you transactional immunity, I can't ever use it.
Got it. So the fact that Lisa Marie did not testify to the obstruction that she was given immunity to testify regarding, does that open her up to now possibly being prosecuted for the obstruction she was going to testify about?
Possibly, but it would be under a grant of the use immunity. If they gave her transactional immunity, even if she never testifies, she's protected forever.
I see.
The use immunity, now theoretically they could say, hey, you admitted to it, so we're going to use it against you. The problem is they can't, if she takes the stand and says, I never said I did it, they can't impeach her because she was never under oath. But if it's transactional immunity, they can't ever prosecute her. But if it's use immunity, they still can. But in this case, the use immunity isn't terribly helpful because there was never a statement made under oath that she's going to be protected with. So
Right. So I mentioned this earlier, but I'm just going to say it again. The fact that the use of Lisa Marie's testimony was only going to be either prior consistent statement or to give some color about obstruction that we haven't quite had in this case to the degree that she's going to be able to speak to it. And if they decided, well, we don't really need any more prior consistent statement testimony at this point, then it still seems to me that the only reason the prosecution continued to be interested in Lisa Marie's testimony at this late stage of the trial was because of this obstruction issue. And I don't really understand why they would have been interested in that, since that's not an issue in this case. That's much more of an issue in the civil trial.
So it is possible, and I have no firsthand knowledge. I haven't read any of the pleadings. I haven't read any of the documents that have been filed of record in this matter. It is possible that the prosecution was trying to find a way to legally, and not improperly, legally get in some Scientology stuff. And this goes back to the opening the door, right? Let the defense do the direct examination. The prosecution does the direct examination of Lisa Marie. They get out of the way, and maybe they've asked a question that the defense just can't help themselves but ask a follow-up question about. That opens the door, since the defense, who was the objecting party to secure the limiting instruction, if the defense opens the door, the prosecution is then allowed to walk through it and examine on it on redirect.
Right.
And so possibly trying to set up a back door, it sounds underhanded, but it's not. It's a perfectly legal way to do it. And they may have decided, you know what, it's not worth the time and effort. I mean, if we end up on this 6-hour redirect, I got 2 people I can't call because I'm out of time.
So I was just reminded, like I just remembered that even in the opening statement, the prosecution did say they were going to introduce, they either said 17 or 27 pieces of evidence regarding, they didn't say obstruction of justice. They meant, they said something about preventing, actually they mentioned harassment. They weren't even talking about the obstruction. They were talking about the harassment. The prosecution actually said, we're going to be introducing 17 to 27 items of evidence about the harassment that these Jane Does have been subjected to. I was conflating that in my mind as I sat here with evidence regarding obstruction.
Right.
Because does it strike you as correct that obstruction in this case at this point is not relevant to the case? It's not, right?
No, because if Danny Masterson engaged in obstruction, he hasn't been charged with it.
Right.
If Lisa Marie Presley's been charged with obstruction, she has or has been engaged in obstruction, she hasn't been charged with it. Scientology arguably did. I mean, we could theoretically say conclusively, but there hasn't been a legal finding by a fact finder. But Scientology has engaged in harassment or in obstructions, but they haven't been charged with it.
Could efforts to obstruct be construed as admission of guilt on the charges? No.
No. No. It's for that very reason. And there will be, one of the things that I would love, and I don't know if Tony Ortega has the ability to secure this. I certainly don't know him. I know you've got at least a working relationship with him. I would love to see what the parties are going to file as it pertains to the jury instructions. Most states have a set of uniform jury instructions. And so for the charges Danny Masterson's facing, it's a template. And then the parties, some of the language is stock. And then the parties argue, the attorneys argue over the nuances of how they're going to present it. But that is the charge that's read to the jury. And they literally start jury instruction 1 to jury instruction 2, 3, 4. I would love to actually review those and see what both sides are positing, because 90% of them are going to be the same. It's that 10% that is going to win and lose the battle. I'd be curious to see what each side is arguing from the jury instruction, from the jury charge, and then ultimately the judge will conduct what's called a charge conference, where she meets with both litigation teams, both sets of attorneys. They argue their respective positions, and the judge says, "Here's the instructions that are going to be read." And just like we talked about last, I think it was yesterday, whenever we spoke last, one of the things that happens all the time is all of that will be transcribed by the court reporter. Because an erroneous jury instruction, or because the jury instruction is the law. The judge tells the jury, this is the law that you have to apply. You are the fact finder. Your job is to take the testimony and the exhibits and the evidence and apply them to the law that I gave you to find out what happened. That's your job. If the judge gets the law wrong, that is reversible error, because the jury is now trying to apply an incorrect law.
Well, it looks like we're going to get the jury instructions on Monday. Are those instructions something that will be read aloud in court? Because if so, they should be in Tony's notes.
Yeah, so the proposed jury instructions will be filed into the court record. So they'll be filed in with the court clerk's office. And I don't know if California does an e-filing system. I would assume they probably do here in Oklahoma, where it's just sort of the dark ages still, at least in terms of the court procedures. We still have to physically walk in and hand things to a court clerk where they stamp it. And then if I want a copy, I have to bring a second copy that they then stamp and give back to me. We can pull pleadings up online and look at them and print them, but we still have to physically walk in. But those are actually filed in the court record, and the judge will, of course, get copies of those. And then the final instructions that are read to the jury will be both printed copies for the jurors to read along with the judge, and then the judge will read them as well. The charge conference, although is technically public, will generally be heard in the judge's chambers, or essentially the judge's office, because whatever changes the judge decides to make, she'll just type those out on her computer. So rather than making those notes and having to go back and type them later, we just type them in real time. And we have generally that charge conference would be held in chambers.
Very interesting. So I don't know if you've seen any of the updates today, but it looks like there is no court tomorrow. And it looks like the prosecution is, they haven't officially rested their case. I think they're going to wait until the jury comes back on Monday morning to rest their case in front of the jury. It looks like the defense may not even be calling any witnesses.
That's not a huge surprise to me. And so you're right. They do. So the judge, all the attorneys are fully aware that the defense is finished, but there has to be the formal resting of the case. The jury will come in, take their seats, and then she'll say, Mr. Mueller, call your next witness, at which point he will rise and say, Your Honor, the state rests. And then she will then look at the defense counsel and say, the defense will call their first witness, at which point the lead defense, or whoever the designated defense attorney for this part will rise and say, Your Honor, the defense rests. And then the judge will probably retire the jury back to the jury deliberation room or wherever she's holding the jury while the charge conference occurs. They get the jury instructions finalized, and then she will formally charge the jury.
So I know you said earlier in one of our previous chats a few days ago that it's not that uncommon to not call any witnesses for the defense, particularly if you think the prosecution hasn't made its case. Mm-hmm. But the defense had 3 expert witnesses it was considering calling. What would be going through their minds in deciding to not bother?
So it's an interesting question, and here's why. Expert witnesses, and I apologize, I don't know a better way to explain this. They're testimonial whores. So generally speaking, opinion testimony, what Aaron thinks, what Aaron feels, what Aaron ponders is not admissible. Lay witnesses, which are not expert witnesses, lay witnesses are only allowed to opine as to their 5 senses. I heard, I smelled, I tasted, I touched, so on and so forth. Expert witnesses are allowed to give opinions. But in order to give an opinion, you have to be qualified that you have a unique set of skills or knowledge that is not available to the average layperson. And if for, I hope most of your viewers have seen the classic, My Cousin Vinny. Marissa Tomei, who traditionally we see this engineers, doctors, psychologists, psychiatrists, think Johnny Depp, all the doctors, right? But Marissa Tomei in that movie, she's just a mechanic, but she's an expert in auto mechanics. And to establish it, what have you done? I rebuilt transmissions. I did oil changes, brake jobs, lube jobs. She established that she had the skill set and then explained that to the jury. The thing about experts are, and as an attorney, I love cross-examining experts because it's a sparring match. Can I be quicker and wittier than you? You went to law, I went to law school, you went to med school, or you went to, postdoc or whatever. And it's also a battle of the experts. And I actually had this. I'm going to give an example from a case of mine. I represented a lady who'd been injured in a car accident, and one of the disputes was the value of her medical bills. And the defense, as is their right, the defense called and hired a medical doctor who was an orthopedic surgeon to evaluate her injuries. I took his deposition, a little different because it's a criminal case, but I took his deposition, but it was a video trial deposition because he was like, I don't know, $10,000 a day to call it trial. So instead we just did it in his office at like 6 o'clock at night. And then if they wanted to call him, we would just show the video in trial. They did this several times in the Depp Heard case. So at his video trial deposition on cross-examination, I did a pretty good job. And I said, she has the right to choose her own medical treatment. You don't disagree with any of this treatment. And then I said, well, what about the billing? He says, I'm not a billing expert. I have people in my office who bill the insurance companies or bill patients. I don't know what we charge for these services. I show up to work and do my job. At trial, the defense elected not to call him because I was able to do more harm to their case than he was able to do good for their case, because I essentially got him to agree. The treatment she got was reasonable. The doctors she saw were qualified to treat her. The diagnoses were correct. The medical records were complete. He didn't disagree with anything. The dispute was over billing, and he said, I can't talk about billing. I don't do my billing. I have a billing clerk who does that for me. So they ended up not calling a medical expert in that case.
Right. Okay, that makes a lot of sense. The one thought that I had while reading the transcript of all this is that the judge seems to very much want to move things along. Obviously, the prosecution is in favor of that. Is it normal for the defense to be cooperative in speeding things along, or is it generally in their favor to drag things out?
I think that's going to be fact specific. When I say fact specific, right? So the old joke is the best lawyer is a one-handed lawyer, because you can't have on the one hand and on the other. He's a one-handed lawyer, and that's sort of an example of this. It's hard to know in a vacuum, but essentially, yeah, they have an interest in moving this along because they are fully aware that the jury has been sitting here for, what is this, 3 weeks now, 4 weeks, and they try to be respectful of the jury's time. And especially in this case where there's been days at a time where the jury isn't there, most of those jurors go back to work for a day or two, and then they're out and they're back to the courthouse and they're missing work and they're missing their families and all this other stuff. So it's inconvenient for the jury, and every trial lawyer should be very cognizant of the jury's time, because if I make the jury mad, I'm not going to win, right? I'm just not. Even if I've got a really good case, the jury's going to go, I didn't like him. And so I want to be respectful of that jury. And in fact, every jury trial I've tried, every judge I've appeared in front of on a jury trial, always thanks the jurors. Ladies and gentlemen, thank you for your service. This is not an easy task, and it is a task that makes our system of justice unique to anywhere else in the world. And it's a big ask for you to be here, and we appreciate your attentiveness to this matter. So it is very important that they respect the jury's time. So I'm not terribly surprised that the defense is trying to expedite this as well.
Very interesting. Did you have a chance to read the Jane Doe 4 testimony yesterday?
I didn't get a chance to read it, but I actually was doing, when you and I talked yesterday about setting this up, I said, hey, there's a few things I need to look at tonight. And one of the things I was looking at was, under what basis would they have called her? And I haven't read the transcript, but I think I've got a pretty good idea of why they called her, because for those who maybe are tuning into this one and didn't see our most recent discussion, Jane Doe 4 is a Danny Masterson accuser. Has made 2 allegations against him dating to 1996. The judge has said that she is allowed to testify about the first encounter in 1996, but not the second. Okay. Now, and I dug out, it's a little old, but my federal rules of evidence, because I wanted to talk a little bit about methods of proving character. Proving character can be a good.
Can I want to see if this helps you,
Sure.
or steers you or directs you. She was called as a past bad acts witness.
Okay. So past bad acts, and that's, so it does, so instead of looking at 4 rules, it sort of narrows it down to like 1 in the exception. All right. And so rule of evidence 405, so it would be federal rule 405, and in Oklahoma it would be 2405, and there's some corresponding equivalent in California state courts. Rule 405 is called methods of proving character, and there's 2 ways to do that: by reputation or opinion, or by specific instances of conduct. This is the specific instances of conduct. And so the rule actually reads, when a person's character or character trait is an essential element of a charge, claim, or defense, the character or trait may also be proved by relevant specific instances of the person's conduct. Okay. Now, the way it's worded is weird, because I didn't read A, so A ends in a semicolon, so it's a continuation, subpart B. That's why it's worded the way it is. And so what this shows is, and then there's also rule 406, which is habit or routine practice. Okay. So even though he probably will never be prosecuted for those wrongs against that individual, likely because of the statute of limitation, which part of the research I did yesterday was looking into some of that stuff, but she is allowed, if the defense's position is, this is unlike him. Other than these 3 women, nobody has ever made these accusations. Nobody has ever stated that this is his method of doing this. Well, rule 405 and rule 406 allow me to call witnesses to prove that.
Interesting. So earlier in the case, very early on in the case, there was a moment when the defense, well, I don't remember if it was defense or prosecution, somebody asked Jane Doe 1 whether she had spoken to other victims, and Jane Doe 1 said, "Do you mean any of the other of the named victims?" And the defense lost their mind. They were like, oh my God, they've prejudiced the jury. Now the jury knows there's other unnamed victims. This is unconscionable. We must have a mistrial. So that was a nice piece of comedy there. And it's a little ironic to me that they threw such a big deal about that then, and yet one of the unnamed victims literally ended up testifying.
Well, so, and Aaron, one of the things that I think is interesting, and this is perhaps a strategic mistake by the defense, although I'm of course not there. That's not a bad argument to make, but I would time it differently. I would wait till my opportunity to cross-examine that witness, because if I cross-examine that witness and I am unable to what we call rehabilitate that witness, I can't flip that witness's testimony in a way that is less damaging or to Danny, or fixes the damage it did to Danny Masterson's case. Now I can say, Judge, this is prejudicial. We need a mistrial because I attempted to rehabilitate and the witness cannot be rehabilitated. The jury cannot unhear, and a curative instruction is not going to be enough.
Interesting.
So sort of I thought it was interesting that they timed it when they did.
Interesting. So something really crazy happened yesterday, and no one knows why it happened yet. The instructions were so crystal clear that Jane Doe 4 was not allowed to speak about the second incident. Prosecution was not allowed to lead her there. There was even a moment where it looked like they were about to, and the judge said, whoa, you dismiss the jury. You better not be trying to lead her to the second incident. And it's like, no. Okay. Then the prosecution said no more questions for this witness. Before Philip Cohen could stand up and start doing the cross, he asked for a sidebar. And whatever it is they discussed at the sidebar, the prosecution resumed their direct examination and asked her every tiniest detail about the second incident, and nobody knows why. Nobody knows why.
I saw Tony Ortega's report about that. I saw his. I watched his video that he uploaded about that yesterday afternoon or evening. I thought that was interesting as well. I have no idea tactically, strategically what the thought was there, but I think he hit it on the head when he said, obviously, there's an agreement between the parties, right? Because here's the thing about court. Judges have every right to, what we call, the Latin term is sua sponte, have every right to, on their own. A judge can object and sustain their own objection. That's within the purview of the judge's oversight of the trial. They never do. I've never, in my career, I've never seen it done, and I don't personally know anybody who has. Most judges take the position of, I'm going to sit back and let you advocate your case. It is not my job to say that's hearsay, that's not admissible. It's your job as the advocate to know the rules of the game, right? And I'm going to sit back as the referee, and unless you ask me to call a foul, I'm not going to call a foul. Okay. And I know a couple of your viewers aren't sports fans. They didn't track my NFL metaphor last time, but I beg their forgiveness for this case. But it was, if the parties agree to let that come in, it comes in, and it's not grounds on appeal that the judge let it come in if the defense didn't object to it. If the defense objects and loses the objection, theoretically, if the judge erred in overruling the objection, that could be reversible error. I can't conclusively say.
So what makes it so confusing is that not only did the defense not object, but it seems like it was the defense. I mean, it sounds insane. It seems like the defense is the one that requested it, which Cohen's the one who asked for the sidebar before beginning his cross-examination. The next thing you know, Jane Doe's talking about, the second incident. It doesn't make any sense to you, right?
No, yeah, exactly. I don't know what happened. It's really strange too, because that sidebar is recorded in the transcript of the proceedings that day.
Really?
Yeah, the objections, the sidebars, because generally speaking, the jury should not hear counsel's argument about why something is or is not admissible, because we're oftentimes talking about things the jury has no idea about. So the way objections work in every trial I've ever been a part of, the attorney will stand and state their objection. Objection, relevance. Objection, hearsay. Objection, leading. Sometimes that's enough for the judge to say, yes, I agree, or no, I don't. But if the other side wants to respond, or if the judge wants more information, the judge will call the parties to the bench, and they will have a sidebar out of earshot of the jury. But you see a lot of the court reporters have the headphones on. Most of the time there's a little microphone up there, and they're actually, the judge will ask questions, the attorneys are arguing their case, their position, and the judge will say, I'm going to sustain it, or I'm going to overrule it. They go back to the table, and the judge makes the pronouncement to the jury. That objection is overruled. The witness is instructed to answer.
So we will eventually be able to see what was said.
Yeah. Yeah. Once that transcript is made available, anybody who wants to go pay the fee to purchase a copy of it has every right to do so. It's a
As
public
of right,
record.
as of right now, it's like $1,300. Someone checked.
Yeah.
It's ridiculous. So is it unusual in this case? The one thing Judge Almeida has been doing is she's been interjecting asked and answered objections to keep proceedings moving along. Is that even unusual in your experience?
It's unusual. So that's what I was talking about earlier, where a judge can sustain his or her own objections. Now, Judge Almeida can't say relevance overruled and overrule her own objection, but she can make a legal finding that's asked and answered. I've never seen it happen to me personally. I don't want to say it's common, but it's certainly not rare. We even saw this some in the Depp Heard case, right? Where they were literally, it's a civil case, so they were on the clock. The judge says each team gets so many hours to try this case total. And then she would say that more than once she told Johnny Depp's attorneys, counsel, move on. We've beat this horse, move on. We've got other things, other matters we need to attend to. Let's progress, please.
Makes sense.
So it happens.
Okay, so it looks like Monday morning the prosecution will rest. It looks like the defense will not call any witnesses. If they do, it'll be one expert witness, and it looks like the jury instructions will be given sometime on Monday. And I don't know. Does that mean deliberations will start immediately, or would they postpone it to Tuesday?
So it would depend on how quickly the charge conference is able to be had, and that's why both sides submit their proposed instructions early, because I would suspect, like in this case, I would, it's not uncommon to see a jury instruction packet be 70, 80 pages, because it's one instruction. Well, it's just one instruction per page.
Oh.
Right. So, and if there's 3 charges and each charge has 5 elements, each element's going to have its own page, and then that's repeated 3 times. That'd be 15 pages just with the elements, right? So I could see where the packet could be 70, 80 pages easy, because it's just one instruction. And some instructions are one sentence, some instructions are 3 paragraphs. So it's sort of one at a time. Each state does it different, or each state can do it different. But the uniform method that I see most common is the judge will charge the jury, read the instructions to the jury, so the jury knows what they're supposed to do. Then the sides get to put on their closing argument. Because a closing argument doesn't mean much if the jury doesn't know what they're supposed to be watching and listening for.
That makes a lot of sense.
The jury would get charged, and what no judge will do is charge a jury at 4:30, adjourn them for the day, and then do closing arguments the next morning. They want the jury instructions to be fresh. The jurors will probably have a copy of it in their hand, so they're able to follow along as the closing arguments are presented. So if the charge conference isn't concluded by noon, I fully suspect that the judge is going to want to start the charging of the jury and the closing arguments fresh on a new day.
Got it. So deliberations beginning Tuesday and going for as long as they need to, but it looks like almost certainly will be wrapped up before the Thanksgiving holiday. And
don't think for a minute the jurors don't know when Thanksgiving is. That sometimes it could be if the jurors are fighting amongst themselves trying to figure out exactly what they want to do. Sometimes that's a motivation to help jurors sort through the material faster. Right. And one of the things I think it's important, and part of the reason I said I'd like to read the jury instructions if I was able to secure a copy of them. And this is very important, but nobody knows this. I didn't even know this until I was in law school, and I had a master's degree already when I went to law school and had been working professionally. There are 2 different things in the law. One is called a factor. One is called an element. An element is required. And so a factor is something that a jury or a judge can consider. But if it's present or not present, it doesn't matter. If it's present, they may give it more weight. If it's not present, they may give it less weight. But it doesn't matter if it's there or not. An element is required, right? So if one of the elements for Danny Masterson's the charges against him, if one of the elements is lack of consent, the prosecution must show beyond all reasonable doubt there was no consent. And those elements are laid out in the charging documents. That's why I was curious to see exactly what the jury instructions would be, because that will outline specifically what those elements are. And then each of those elements is defined. So the crime is defined. Sorry, I'm going the wrong direction. Crime is defined by the elements of the crime. But that doesn't mean anything if we don't give each of these elements a definition. And that's why the jury instruction packets are often very thick, because if my crime has 5 elements, each of those elements has to have a definition.
Got it. Makes sense. Well, I'm going to save my Paul Haggis questions for later because I've got a hard stop here in about 60 seconds. Quick mention, because I'm doing this as often as I can. Any of you who want some of these super awesome Mike Rinder bobbleheads, jump over onto the spshop.com. All the proceeds from the SP shop go to the Aftermath Foundation, which helps people who are escaping from Scientology. All right. So, well, let's do this. Let's see. Court's back in session Monday. Let's do something on Monday. You around? Should you?
I'll be here. We'll get it done.
Awesome. Thank you guys for joining us, and we'll talk to you soon. Bye.